Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing a recent decision from a British Columbia trial-level court about Aboriginal title and private property. The case was brought by the Cowichan Tribes against the governments of BC, Canada, and the City of Richmond on August 7th. After a 513-day trial that stretched over a year, Justice Young issued a groundbreaking decision. She found that the Cowichan had successfully proved they hold Aboriginal title over land located in Richmond. The most groundbreaking aspect of the case, though, was that it was the first time a Canadian court has issued a decision that could invalidate fee simple title solely based on claims of Aboriginal title, elevating the constitutional force of Aboriginal title over registered land interests. Now, fee simple title is the strongest and most complete form of land ownership recognized in the common law system. If you own a home, it's likely in fee simple. It gives you exclusive rights of indefinite duration. And when we speak about land as private property, we're generally referring to it as fee simple property. There are fee simple property owners in Richmond who were not a party to this litigation that has now unsettled their title. They include some residential property as well as commercial and industrial properties. Much to the surprise of many, the court emphasized that registration under BC's Land Title Act is not necessarily conclusive when Aboriginal title comes into play. And the decision rejected the idea that the Crown's fee simple grants automatically extinguished Aboriginal title. Justice Young found that Aboriginal title is a senior interest in land vis-a-vis fee simple, which derives from the Crown grants. This, as I said, has unsettled the relationship between Aboriginal title and fee simple, and now all three levels of government have appealed. Here today to discuss the case are two of Canada's leading lawyers on Aboriginal title, Professor Dwight Newman and lawyer Tom Isaac. Thank you both so much for joining me today. Let's start with you, Tom. Can you tell me a little bit more about the background of the case? Who were the Cowichan and what are they claiming?
The Cowichan is a First Nation Situate on Vancouver Island, and they were in this particular case claiming Aboriginal title, if you know the Vancouver area, on the Lower Mainland in Richmond, the City of Richmond, and at stake were 1,800 acres. Ultimately, title was found by the judge in the decision over 800 of those acres, involving private property and some Crown land as well.
So, Professor Newman, maybe you can tell me a little bit more about that land at issue. What exactly is there? I said there's some residential property, there's some commercial, industrial property. What is actually going on with this land?
The Cowichan, as a number of other First Nations have done, strategically excluded the actual private land from a request for an order on that. But it is within the Aboriginal title claim area. So there are different facilities there. I gather there may be some residential, but there's also some sort of warehousing facilities and so forth. The City of Richmond has some infrastructure there. And it happens to own some land in fee simple because it had taken that back from people who hadn't paid their taxes, in essence. And so they ended up with this fee simple land. So the judge ends up pronouncing one fee simple land, even though in theory, fee simple land, well, private property fee simple land wasn't going to be subject to the order, but then the judge pronounces about fee simple land in a way that could implicate private property owners.
Now, this is a big question, Tom. We've only got a minute in this segment, but what does Aboriginal title actually mean? How does it get established?
So it gets established by First Nations bringing forward evidence that they exclusively occupied the land prior to the assertion of British sovereignty. And if they're relying on current possession today, they have to show continuity. So there's a very high evidentiary burden on them. In terms of what Aboriginal title means, we know from the Supreme Court of Canada has been very clear, and I think contrary to the decision in Cowichan, it's not a typical interest in land. You were talking earlier about fee simple or private property. As the court has stated a few times, It is a right to the land itself. It's a possessory right, in my view. So to describe it as an interest in land is, respectfully, I would say, is not accurate. It's a right to the land.
I see. Well, let's get a little bit more into it after this commercial break. Welcome back to Canadian Justice, where we're discussing a recent decision from a BC trial level court in a case called Cowichan Tribes in Canada that has disrupted or unsettled the relationship between Aboriginal title and fee simple private property. Now, Dwight, in the last segment, we were talking about what exactly Aboriginal title means, how it gets established. And I'm really curious about what it means if a group has Aboriginal title. What does that actually mean they can do with that land?
Well, it means they're the owners of the land in a full sense. They manage the land, they get the economic benefits of the land, they own the land, in terms of the characteristics that the Supreme Court of Canada has set out. If anyone else wants to do anything else on that land, they need to do it with the consent of the Aboriginal community. That's something that's in the Chilcotin or Silcotin decision, discussed at some length. So it becomes the land of that Aboriginal community, at least as the Supreme Court of Canada has described it. Now, we have the government of BC that a while ago was saying things that don't exactly fit with that, saying, well, maybe Aboriginal title and private property could coexist somehow. That's really difficult to understand in terms of the way Aboriginal title's traditionally been understood.
Yeah, I think that that's what a lot of people who have read about this decision are trying to grapple with. Because the court kind of here has said that there's a coexistence. There's fee simple that exists at the same time with the superior interest of Aboriginal title. Tom, how can those two interests exist simultaneously under the reasoning of this decision?
Well, again, I'll pick up on what Professor Newman has just said, that certainly based on the law today under the Supreme Court of Canada, they can't exist. They are both exclusive rights to land. As you described fee simple, which I agree with your description at the beginning of your show, and then you look at what the description is of Aboriginal title, they're both exclusive rights to or in land. Well, I think for any of your viewers, whether you're a lawyer or not, you obviously can't have two parties both having an exclusive right to something. And so it's really that simple. What the court seems to have done, which mirrors what the province has purported to do in the Haida Agreement, is somehow suggest that these two exclusive rights to or interests in land can coexist. But it isn't consistent with, in my view, the Supreme Court of Canada guidance. So that then begs the question of, well, what is it we're really talking about? Is it Aboriginal title at law, or is it something else?
Yeah, you mentioned the Haida. It's not a decision; it's a consent agreement, and how
Yes.
that might relate to this. Dwight, maybe you could expand on that. There's been this recent order from a BC court on a consent agreement between the Haida Gwaii and another group. I think it's the government. What can you tell me about that consent order and how it relates to the Cowichan decision?
So the consent order is pretty unusual because it involves a judge declaring the existence of Aboriginal title over all of Haida Gwaii, just through this consent order done in chambers, in a not a very transparent way. That said, it does flow from the agreement between British Columbia and the Haida in certain respects. It goes further probably in terms of some legal effects of a judge making that declaration. But going back to that agreement, the British Columbia government was going to concede Aboriginal title over all of Haida Gwaii, subject to some kind of an arrangement where the Haida were committing to respect private property. But it's challenging to see how those fit together, and there have been law firm comments on that over the last number of years since the agreement was reached. And it still remains challenging to see how Aboriginal title and private property fit together in the way that's been done now.
Yeah, I mean, this case is the Cowichan is certainly a different set of facts, and I want to get into this in the next segment. But a lot of what the commentary has been from mainstream media, a lot of what people who have read about this are concerned about is how does this affect my home? How might, if I live in British Columbia, how might this affect my private property? And the judge in Cowichan actually said private property owners are unaffected by the decision. I'm not entirely sure if that's accurate, because certainly it would have an effect on real estate values if there's an unsettlement of title. But when we come back from this commercial break, let's talk about the broader implications of the Cowichan decision. We'll be right back. Welcome back to Canadian Justice, where we're discussing a recent decision from the BC trial level court in the case of Cowichan Tribes and Canada. This case has unsettled the relationship between fee simple private property owners and Aboriginal title, with a sort of surprising finding that a Aboriginal title could actually usurp this fee simple title, or that they could even exist simultaneously. And I think, Tom, one of the questions a lot of private property owners in Richmond, in British Columbia more broadly, and even in Canada want to know is, what are the implications of this? Does this mean that there could be Aboriginal title existing simultaneously on my private property that I own and I just perhaps don't know about it? And if it is, what does that mean for my property?
Yeah, well, there's been, I think, some commentary that maybe the decision isn't quite as bad as maybe some are suggesting, or that it doesn't have broader implications. To be absolutely clear, to use the judge's own words, she wrote, "A precedent that will flow from this case is sections 23 and 25 of the Land Title Act do not apply to Aboriginal title." Well, sections 23 and 25 of the Land Title Act in British Columbia are really the guts of private land ownership, and they are core to our economic system. The court could have restricted its reasons to the 800 acres that have found Aboriginal title on. The court deliberately and expressly said, no, it's going to make a broader statement around the effects of its decision. And this is what is so concerning. And again, with respect, I would say flies in the face of existing law from the Supreme Court of Canada. My point being, anyone suggesting that this is simply restricted to the City of Richmond or the 800 acres, that wasn't the express intent of what the court wrote.
Dwight, anything you want to add there? What might this mean for the private property owners in Richmond or beyond? I mean, I know that the Cowichan were not seeking an invalidation of the private property owners' fee simple title in Richmond, but does this open the door to that possibility if they were to seek such an invalidation?
It does open the door to that. I mean, the judge saying that they're not affected, there's a sense in which that's technically true. They're not directly affected by this judgment, but they're indirectly affected by the things said in it, just like Tom has said. And not just those in Richmond, but those in any place where there might be Aboriginal title. Now, in terms of why people shouldn't panic quite today, it is a trial judgment and there's going to be an appeal. I guess I'd also say there are legal complexities. Different parts of the country have treaties that may actually have resolved Aboriginal title. And so people need to think about where they are and what issues are there, as well as the idea that judges might at the end of the day be practical people and not make such an impractical declaration. One judge might be willing to do it, but are the courts as a whole really going to overturn private property in Canada? They might, but I see it as a risk, not as a likelihood.
Tom, do you think that this is an issue that is more relevant in BC? As Dwight said, a lot of the rest of Canada does have treaty. BC is a bit of an anomaly in that it has a lot of land that doesn't. And So do you think maybe the impact, if it is this broad potential impact, is more confined to British Columbia?
Well, look, certainly British Columbia, the entirety of the province is essentially claimed by title. But there are other parts of Canada in very similar situations. There are claims throughout the Atlantic provinces. There's claims existing in Ontario. Currently, there's litigation in the province of New Brunswick, where the entirety of the province of New Brunswick is being claimed by two Indigenous groups. And one of those Indigenous groups is also directly attacking private property rights. So yes, while British Columbia is a bit of a focal point, just given the breadth and scope of the number of First Nations and the lack of treaties, generally speaking, it's a live issue across the country.
All right, we've got to go to commercial break now, but when we come back, I want to talk about some of the really interesting evidence that came out in this over 500-day trial. There's some pretty interesting stuff that the court actually had to grapple with from an evidentiary and factual level. We will be right back. Welcome back to Canadian Justice, where we're discussing the recent British Columbia decision in Cowichan Tribes and Canada. This is a case about Aboriginal title, where the Cowichan claimed Aboriginal title to certain land in Richmond, British Columbia. Now, I had said earlier in this episode that the claim was brought by the Cowichan Tribes against three levels of government, the City of Richmond, British Columbia, and the federal government. But it was actually more than that. It was also between the Cowichan and some other bands. So, Professor Newman, maybe you can tell me a little bit about who those other bands are and how the judge dealt with overlapping claims between different First Nations groups.
Okay, I mean, there's a dispute with the Musqueam and Tsawwassen, and I guess part of this is over fishing rights, and that part of the judgment just hasn't gotten as much attention, understandably, given the implications of the Aboriginal title part. But there is an issue about fishing rights in the Fraser River on the mainland side, when Cowichan are typically thought of as on Vancouver Island. But there's an overlap in some ways in relation to the title issues. The Cowichan have to prove for title purposes that they had exclusive sufficient possession at the time of the assertion of European sovereignty. And to prove exclusivity, one of the ways they do that is to show that other First Nations would respect their claim to that land, even if they weren't there, because this was land they said they were using seasonally. And so there's some pretty interesting and even graphic evidence they put in of how they had intimidated other First Nations historically at that moment of the assertion of European sovereignty, and sort of an awkward aspect to the judgment as a result.
Yeah, you've written about that, and it's a really interesting part of the judgment, going through some of the history of this land and some of the things that happen on that land. And one of the things that you've written about, Dwight, is what you call a morally awkward aspect of not this case specifically, but actually the test for Aboriginal title, which requires this exclusivity over the land. And this test, this requirement, it inadvertently actually requires extreme levels of violence. Maybe you can tell me a little bit about that and why that is actually part of Canadian law.
Yeah, well, I mean, at least it rewards extreme levels of violence. There might be some other way to show exclusivity, just if there were a village there that were there all the time. But in the case of land used seasonally, the way that they showed this exclusivity, the choice of their lawyers, and reasonably given the test, is they put in evidence of how much they had intimidated the other groups, that they were threatening the Musqueam chief, and they were taking slaves, and they had skulls of their opponents and enemy First Nations posted up on posts along their territory. Pretty graphic stuff. And I don't know that this is positive for reconciliation, to be rewarding those things, and to be sort of drawing them up in a court case like this, but it is an inadvertent consequence of the exclusivity arm of the Aboriginal title test that those can qualify for proving exclusivity.
Now, this is all historic evidence because this is all designed to show exclusive use of the land over a very long period of time. But that's really interesting to me because it requires, reliance on archaeology, on oral history, and all kinds of expert evidence. Tom, maybe you can, in the last 30 seconds, tell us how the court dealt with weighing these different types of evidence.
Well, I mean, I think in the end, the court weighed in favor of the Cowichan. I think the issue is that a reasonable weighing? Going back to something that Dwight had said a little bit earlier, is it ultimately a reasonable decision? And that includes in terms of the private property landowners. So as you say, there's a multitude of interests here, but when you weigh it, is this really reconciliation at the end of the day, the very thing that the Supreme Court of Canada has been focused on? Mm-hmm. Certainly, I've been quite vocal in saying that I don't think it's a reasonable version of reconciliation.
Mm-hmm. That's all the time we have. Tom, Isaac, Dwight Newman, thank you so much for joining.
Thank you.
Thank you.
We've heard today about the new British Columbia case that has unsettled the relationship between Aboriginal title and fee simple private property in Canada. What do you think of the broader implications of this case in Richmond, BC, and beyond? How might this impact reconciliation? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.